The intention of the Rapid Response webinar was really to go over some of the things that were in the Rapid Review of ASQA report findings. Some things that I thought that providers might not have picked up and sort of really grasped what was going on. One of the things in particular was in relation to new standards. I think that a lot of people may have actually completely missed that because there was only a very small reference to it at the beginning in the executive summary, but there was a much larger reference to it sort of halfway through the report. And I think that a lot of people wouldn't have got that far into it or really not paid that much attention and not really understood a lot of stuff that was going on. And so I guess there were a few other things like that as well that I thought, well, I wonder whether people have really had the time to acknowledge everything that's in the Rapid Review findings and recommendations because of when it landed to begin with, in terms of right in the middle of COVID-19 and people trying to implement strategies just to survive and keep their students and staff safe, but also just in terms of the workload that they've been under and the way the report's been written as well. While it's not a huge report as far as, for example, the Joyce review and the Braithwaite review, it's still quite a long report in terms of the timing of when it was launched. And so I just wanted to pick up on a few things, and hopefully we can have a discussion about some of these things, because I really have pointed to a few questions that I think we should discuss as a sector and see how we feel about them. But the intention of the findings of the Rapid Review was to shift over time ASQA's regulatory approach from a prescriptive and process-based compliance model to a broader focus on self-assurance by training providers and excellence in training outcomes. This will support providers to identify and rectify issues without undue regulatory intervention and to build their capacity for continuous improvement. So according to the review, the main questions, the terms of reference, the main questions that were asked of the sector included: how can ASQA best engage with the sector? What strategies could be adopted by ASQA to support best practice among training providers? What elements of its current educative approach are the most effective? How can ASQA best help training providers to understand their obligations? And what elements of ASQA's regulatory approach do we perceive to be working effectively, and what specific areas would benefit from further attention? So we've been seeing the beginnings of their staged approach very recently through the expression of interest that was sent out for the ASQA Stakeholder Liaison Group, and that closed, I think it was Friday week ago. And what we saw there was, I've actually picked this up somewhere else, but actually I'll come back to that. So in terms of quality, self-assurance and excellence in training outcomes, one of the key recommendations was to move from input and compliance controls to a stronger focus on excellent training outcomes. Now, I looked at that and I thought, haven't we been here before? Like, isn't this just reinventing the wheel? What's going to be different about it this time? And I wonder, what are your opinions on that? We've got a couple of people in the room at the moment. What are your opinions on this quality self-assurance model and producing excellence in training outcomes? Have we been there before? Should we expect anything different? I can't hear anyone, even though I've unmuted everyone.
Huh. Can you hear me at all, Braylene?
Yeah, I can hear you. Thanks, Brett.
Okay, well, I was going to let somebody else go first, but yeah, it almost feels like the Rapid Review is a bit of like a half a job. They haven't gone into, looking at what processes and things were carried out incorrectly in the past, and looking at which things were done poorly that have led to this situation. So there's an acknowledgement there, but it's too general. So that's my initial thought there, is that, yeah, I think it's a substantial shift if they really do go through the business of looking at training excellence results rather than inputs, because that is a seismic shift. And frankly, I've been calling for that for years. But the details, I mean, do they really know what they're going to be looking for, and how will that be, outlined to providers? Is it going to be a case of more closer inspection and understanding of results as seen by employers, as seen by students, as seen by, levels of competence on specific skill sets? That's the kind of stuff which would give it a bit more meat on the bones. Otherwise, it looks suspiciously like it's, the right words, but not necessarily the right intention.
And that's an interesting point that you make, because excellence in training outcomes can be very different and have a very different meaning depending on the audience being asked the question. So excellence in training outcomes, sadly, for the regulator might mean one thing, for the student it might mean another, for the trainer it might mean another thing, but then you've got the employer who could have a completely different understanding of what excellence in training outcomes means altogether. And so we come up with this ever-evolving question of, well, what actually does excellence in training outcomes look like? Is it achievable?
Yeah. Well, is it achievable? And does everybody understand it in terms of what ASQA intends? I mean, one of the criticisms of ASQA over the years has been that it's too distant from the employers themselves and the trainers themselves and the students. So there's a lot of stuff around it, but these are the areas where there seems to be a higher focus on administrivia, I'm sorry, but I think there is, than there is on employer satisfaction with a training company and their trainers. And if you start there, at least you're homing in on employers that are happy and students that are happy. You can probably start to think, well, maybe this RTO is not doing too much wrong in reality, because the standards themselves are still completely nebulous. They kind of have to be, but that's where it is. Whereas if you find employers and students are saying, oh, I wasn't really happy, then that should raise some flags. And you would think it would help ASQA to nail the dodgy ones rather than just going back from a back of house starting point. But that's just my view.
And of course, the rapid review findings also discuss this concept of having an agreed understanding of what quality looks like and what compliance looks like and what excellent training outcomes looks like. They do discuss that, but whether or not that's going to be achievable when we're considering everything else that's been recommended is really a very big question.
Well, I remember, sorry, Raylene, I just remember 2011 when they changed the focus from, I can't remember what it was now, but to outcomes. And I remember speaking to consultants at the time who'd been around a while, and they said, we can't tell what this really means, no matter what information we've got here. We can't tell how ASQA is actually going to apply it. How are their auditors going to see it? How are they going to make their decisions, having got the auditor's report? So I think we're in that same position again. Everybody's now going to be wondering, what does this really look like? And you might be in a situation where, once again, you might find a lot of RTOs running foul, and they're trying to do the right thing. They just don't understand what ASQA is actually getting at. And maybe ASQA itself doesn't until they start doing it. This is the thing, when you don't nail it down in detail, you can't be right. But in a sense, you can't be wrong either.
Absolutely. And I guess that leads me to think about the focus on self-assurance and declarations, and that's really what a big focus of these proposals are, is that there will be a stronger focus on quality self-assurance and people, or providers rather, making declarations that they're compliant, and that ASQA will then just come in and do their monitoring. But I sort of thought about that, and I thought, well, isn't that what we've already got and what we've already had? And so
so the only way I can read that differently, Raylene, sorry again, but the only way I can read that point differently, a good point you've raised, is if they're going to rely on the RTOs a bit more to do it right, because it's in their interest too anyway, how is it different? I mean, are they going to rely on it more? Are they going to do less auditing? Or are they going to look for poor providers from a different perspective so they can leave the others behind? Otherwise, as you say, it's going to be the same thing.
Yeah. And I guess that led me to thinking about the current annual declaration of compliance, and also the ASQA delegation initiative of vet reform in 2014, where those providers who were considered to be very minor risk and had no history of non-compliance were given delegation to be able to administer their own scope of registration and so forth. And I thought, well, it doesn't really sound to me like we're doing anything new here. It really just sounds like we're reinventing the wheel. And when I was thinking about all of this, one of the things that I thought I must bring up and bring to the attention of providers, because I know that when I brought this up in the past with a few providers, they were really quite shocked, and they hadn't actually read or been aware of what I'm about to say. But given that the annual declaration of compliance has recently been completed and submitted by RTOs, what a lot of people may not have realised is that on page 2 of that self-assessment tool, it actually states that it's not a requirement of registration to use that tool to assess the RTO's compliance against the standards, and that the tool does not form part of the standards and has no legal authority. And yet that is actually the tool that is required to be completed for the purposes of submitting that annual declaration. So I think it's a really important point that RTOs need to remember, is that sometimes ASQA puts these things in place to support providers, but because providers don't necessarily know any better, or because they're rushed off their feet, they take it for granted that that is what they're required to do, and often that will lead them to further problems. So I thought I would mention that again, because in this context of quality self-assurance and making declarations, I think that it's important to consider those sorts of things and what we're actually signing before we submit it. I've got a few allergies today, so if I'm rubbing my nose, I apologise.
You're not supposed to touch your face, it's COVID-19.
I haven't moved from the house. The rapid review also speaks consistently about this move from prescriptive detail, which is recommendation number 2, to a focus on quality self-assurance again. But then I started asking myself these questions, and I'd be interested to hear other people's thoughts on these issues. Is it really just setting providers up for failure again by asking them to declare that they're compliant, but there's all this prescriptive detail? Because at the end of the day, we're talking about legislation. It has to be somewhat prescriptive, because law is either, it's black and white, there's no grey. And so is it really just setting up providers once again for failure? Is it shifting the burden of ensuring compliance? But also, is it possible to not have effective standards if they're not prescriptively detailed, given that they are legislation? So how can we have effective standards that produce excellence in training quality and allow the regulator to do their job and give some sort of framework for the sector to operate on, if they're not prescriptive and if they are continuing to be legislation? And then I sort of finished up with this thought and question, and I'll throw it back to the audience. Is this really what's going to drive excellence in training outcomes? We've seen that since the standards were legislated in 2011, that it hasn't actually produced excellence in training outcomes as far as anyone's concerned. Everyone's got their own different opinions on it, but we will maintain some level of prescription because it's legislation. So is that going to drive excellence in training outcomes? And can we have standards that are legislation but not prescriptive.
I've got a couple of thoughts on this. One is that,
And just so that people know, sorry to cut you off, Brett,
yeah,
but
right.
Brett's not the only person on the call.
Sorry,
Brett's the only
people,
one that is
up.
speaking up. If somebody else would like to say something, please send me a message or put your hand up, and I'll make sure that you get your voice heard or your message gets put across. Go ahead, Brett.
Thanks, Raylene. Yeah, look, I don't want to be embarrassed either, but it was put to me by a corporate lawyer, not specialising in this area at all, but had a good understanding, thanks to me, that because there are no prescribed documents for compliance that an RTO can actually fill in, none of the decisions ASQA makes could stand up in law because they don't provide like a standard by which any RTO goes to the point about subjectivity. So you do have to be prescriptive. But what I can't quite get is, yes, it's got to be a regulator to keep the dodgy ones honest. So they're going to have these details about what they need to, regulate on. I get all that. But are they saying, for those of you who we deem to be of good intent, we're going to take a step back in terms of our level of regulation or, auditing of you. And for those we deem to be, potentially dodgy, we're going to hit you with all the, test you against all these details. And I just can't see, from what I've read, I just can't see where that's clarified. I would like to see a statement of intent along those lines from ASQA, so that, whatever the reason is for having this, go and take a step back approach, but guess what? Look out over here. We've got all these details we'll nail you to the wall with. How do we reconcile these two? Because that's going to be about how they choose to carry out their operations, I would say.
Yeah. Look, I can't comment on the legality of tools and like assessment tools and so forth. I'm not a lawyer and I can't provide legal advice. I only read out the section from the self-assessment tool from ASQA that it has issued itself, which actually says that it's not a legal requirement. So I'll leave that for the lawyers to discuss. But you raise a good point. And I guess in the context of the recommendation to move to a more self-assured model of compliance, and particularly in the context of a recent judgment in the Trades Colleges Australia matter, whereby the presiding members stated that where there is a dispute in relation to ASQA's audit findings, ASQA should not consider that its findings are prima facie correct. It is surprising, therefore, that the reviewers in the rapid review of ASQA focused on a quote from the Brighton Pacific case on page 27 of the review, which reaffirms that ASQA relies on the providers to self-regulate. So if it already relied on providers to self-regulate, how will this approach be different? The quote is cut off before the next point raised by the presiding members, which states, perhaps its greatest concern is that it believes that Miss Key does not know what she does not know. This decision, of course, was set aside by the tribunal, and ASQA subsequently, via the Australian government solicitor, appealed this decision and recently won the case. On page 27, there's an interesting quote which really has me asking myself then, is this really any different to what is currently taking place? Is this concept of self-assurance and providers saying that they're compliant any different to what's actually taking place in relation to this prescriptive detail that already exists, and this self-assurance that providers are sitting there saying, well, actually I am compliant, and ASQA saying, well, no, you're not. And up until recently, when we had the Trades Colleges judgment, ASQA always believed, and it was up to the RTO to prove that it disagreed for the purposes of a stay hearing. But in the recent Trades Colleges case, what we saw was that the presiding members, both senior members of the judiciary, both of them stating very clearly that where there's a dispute, ASQA should not consider that its findings are actually correct at the first go. So in this concept of prescriptive standards, quality self-assurance, I really have to ask myself that question. Isn't that what we've already got? Because that's really what this quote is telling us, in my opinion. There's no other questions or anything at the moment, which takes me to the issue of ASQA governance and culture. And I guess I wondered how it is that points 1, 2, and 3 under the topic consistently understand provider performance against standards and in the context of their operating environment really be achieved based on the 3 subpoints below it. So if I go to that particular item, so the item is consistently understand provider performance against standards and in the context of their operating environment. So the 3 subpoints are: fundamental to the effective and consistent assessment of provider performance is a skilled and appropriately trained workforce that has a consistent understanding of the context in which they are assessing performance, the focus of their assessment and communication of assessment outcomes. The second bullet point: this does not mean ASQA auditors must come from the vet sector, but instead that all share certain qualities: integrity, critical thinking, sound judgment, and strong communication skills, and are consistently trained in relation to assessment methodology, interpretation of the standards, the regulatory framework, and the regulated sector. And the third bullet point: the review proposes changes to not only strengthen induction and ongoing training of ASQA auditors, but also to embed a program of internal quality assurance, including regular opportunities for moderation and internal review. So on that basis, I asked myself the question, if this doesn't mean that ASQA auditors must come from the vet sector, how can this genuinely be achieved?
Is it even legal?
Well, I can't answer that question.
Yeah, I know,
but how are they possibly going to consistently understand provider performance against standards and in the context of their operating environment if ASQA auditors are not required to come from the vet sector?
I'd just like to add to that. I mean, it's always been the case that an auditor must audit and ASQA must take into consideration the circumstances that the RTO is in at the time, in the real world, like in terms of the demands on its time and so on, context of the industry. It always has to do that. So this is really just a statement saying the same thing again. But often, in reality, we've seen ASQA often just ignore the circumstances of an RTO at a given point.
And so from there, I sort of started thinking, well, will this continue to compromise the validity and reliability of ASQA findings in an audit? If the person is not from the vet sector and has got no understanding of how the RTO operates, is that really going to enhance quality training outcomes, excellence in training outcomes? And is it okay to expect that auditors have the same competency and currency requirements as trainers and assessors? I've written an article about this previously, and I will put the link below in the video recording when I publish it. But is it okay that we expect auditors to have the same competency and currency requirements as our trainers and assessors? Or is it okay that they don't have the same competency and currency requirements? Should there always be a subject matter expert in audits? What do other people think?
To say on that one, I just wanted to say, I think a lot of the problems with auditing could be solved. Okay, it might be a bit of a stretch for the auditor to be also a subject matter expert, but I can see how that could be done But at the least, there should be a member of the audit team who is a subject matter expert, because they can simply look at things from that delivery perspective that really counts for the employer and the student, and in minutes just go, yep, 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 no, no, no. And they'll tell you also very quickly whether there's good intent here. And an experienced auditor and an experienced consultant like yourself, yes, you'll be able to determine, but I haven't seen enough of that. And that's where the inconsistency comes from with ASQA auditors. If they actually understood aged care, or they actually understood, you know, welding or mining or whatever, that they would be consistently getting the tick to the good ones, and they'd be consistently uncovering the dodgy ones.
I think where they have MOUs with other regulators, for example, you know, they definitely have MOUs with the WorkSafe regulators. They definitely have MOUs with APRA and, you know, CASA and all these different regulators. There's no reason why they shouldn't be using subject matter experts in some of these additionally regulated environments.
Look, I'll give you an example of one which just illustrates it, and I'll stop talking in a second. But the, you know, in aged care, you've got to know how to, you know, shower a person or bath a person. Now, for the uninitiated, I think, oh, well, everyone's got to get down to their bikinis and jump in the shower or something. But that's actually not necessary, and it's not necessary for quality training. You know, you just simulate it. I mean, when you're showering or bathing someone, it's the same as doing it for yourself. It's really, you know, it's just a matter of a few procedures around it, which, you know, you can simulate anyway. However, there have been auditors say, and maybe this is more in the early days, no, unless you're showering a real person before you go on work experience, you shouldn't be going on work experience. It's a non-compliance, and that's just crazy.
I know that I've definitely been involved in a response for a provider where they were deemed not compliant because their plumbing didn't have hot water. It only had a hot water tap where their simulated environment was, and the industry standard is to have hot and cold water. And therefore they had to go to significant expense getting hot water installed, a hot water system and everything in a leased premises, just so that they could respond to the audit effectively. I think that sometimes these decisions do go a bit too far, and you're absolutely right. Where you've got subject matter experts in the room, it completely remove all of those contentious findings. And
it allows the auditor then to focus on the stuff that is genuinely important. And it may be with a quality RTO, there's not a lot of really, you know, critical stuff there, but at least it's saving you a lot of time and money, and you're getting better quality, more consistent auditing. So that's just, I agree.
There were also some contentious statements made that demonstrate that the review has not really been exposed to the behaviour of ASQA staff that many of us see on a regular basis. For example, one comment was, in the event that providers are not genuine or otherwise represent a serious risk to the achievement of better outcomes. Another statement was, policymakers need feedback from those who administer the law. Now, in relation to the first statement, we're going to come back to that in relation to genuine providers. But in relation to the second statement, policymakers need feedback from those who administer the law, I really did stop and ask myself the question, who does administer the law at ASQA really? And is it
kind of everybody, isn't it? I mean,
is it that the people at MP Consulting who were responsible for the rapid review have an understanding that the administration of the law is undertaken by the Chief Commissioner, for example, or the CEO, because they're ultimately the decision maker? Or is it that they don't actually see that the administration of the law is done at a more lower level of the hierarchy, and that the administration is really done by auditors? And so I did question whether or not that really did get considered as effectively as it needed to be, as part of the rapid review findings. There are currently 4 senior executive level roles up for grabs at ASQA, which could assist in facilitating cultural change, although only one really references any of the issues that have been aligned to the rapid review. I had hoped to have a discussion, but it seems like this is a discussion between Brett and I only, because nobody's sort of willing to contribute.
They all want to watch the recording later.
And so some of these questions that I had were, what do you think about these roles? Are they in your minds already handpicked, or are there preferred candidates before the positions were actually launched publicly? In a perfect world, what would ASQA's governance look like? Will the stakeholder liaison group really have an impact? One of the important questions that I referred to earlier in relation to the ASQA stakeholder liaison group was that I received an email earlier this week saying that the stakeholder liaison group had over 350 expressions of interest. And I guess that led me to ask, were you expecting more or less to put their hands up? Is that a significant number in your eyes, or a low one? What would you have considered to be a good number? Now, given that there's over 4,000 RTOs regulated by ASQA nationally, and the vet workforce is in the tens of thousands, if not hundreds of thousands. I don't remember what the latest data is from NCVER, but 350 expressions of interest is not really that significant given the size of the vet sector. For me, I find that quite disappointing. So I don't know how much influence the stakeholder liaison group will have. Were the positions on the stakeholder liaison group and the 4 senior executive level roles that are currently up for grabs handpicked or have preferred candidates? I guess we'll never know. It will be interesting to see who eventually does fulfill those roles, though. I can't imagine that I will ever be selected for the stakeholder liaison group personally. I did actually apply or submit an expression of interest, but I'm
fully expecting to be appointed, yeah.
I'm really not expecting to be appointed. But moving on, I've just occurred to me there may be an explanation a little bit here on the low number. It could be perhaps that they indicated, they described the kind of person they want, and it's quite restrictive because they're saying they want it from only from large organisations and usually senior in those organisations. So that straight away narrows it down to very large RTOs and significant industry bodies and the senior people from them, and they're often pretty busy already. I'm looking at the membership and who's going to be on it.
Yep.
And we've got the CEO of ASQA, who will serve as chair, and other ASQA senior executives and relevant personnel. Doesn't say how many. Subject matter experts as invited by ASQA. A mix of training providers that is broadly representative of the diversity of ASQA's regulated community, including the following cohorts. 2 TAFE RTOs delivering to domestic students. This may include a dual sector institution. 1 community college, 1 enterprise RTO, 1 school that is an RTO, up to 7 private RTOs. This may include a provider registered on CRICOS to deliver ALICOS training. 1 or more vet sector consultants selected for membership through the EOI process. In selecting the mix of providers from across these cohorts, ASQA will take into account factors relating to the nature of training delivery, including scale, modes, locations, diversity of student populations, and provider performance. In selecting the individuals to participate as members, ASQA will make its selection based on those who hold leadership positions and have a high level of operational authority in their respective organisations, are motivated to advance the interests of providers in their cohort, and are committed to developing the broader vet sector. I don't think that it's exclusionary at all.
Okay, yeah,
I think that it does capture a good representation of the vet sector, but whether or not those people were preferred candidates or whether they had people in mind straight away, who knows?
Yeah, fair comment.
So moving on, page 31 of the review includes a table with column 2 describing what ASQA's role isn't and is not consistent with best practice regulation. A section under relationships only highlights, although it's not really demonstrated as a systematic cultural practice in the review, what providers and other stakeholders experience regularly in their dealings with ASQA, hence the sector's demands for cultural change. Now, if I take you to that particular table under relationships, what it says, it's not ASQA's role and or not consistent with best practice regulation. While there will inevitably be disagreements and litigation, ASQA does not adopt an unnecessarily adversarial approach and will seek to resolve disputes as efficiently as possible. Now that's what's listed under it's not ASQA's role and or not consistent with best practice regulation. But for many of us, that's what we experience on a daily basis in our relationship and interactions with ASQA. So for me, it's really important that this is not just a small area in a table buried in the middle of the report, because it is such a fundamental component of ASQA's governance and cultural change that is going to be required. Then, if we go back to recommendation 2, which is what this entire rapid review started with, and that is develop new standards in consultation with the sector. So as mentioned earlier, it was only a short reference in the executive summary. In fact, if that's all you read of the review, you might have blinked and missed it. The reference to it was so small. It's on page 4 in brackets, third bullet point under promote and facilitate a culture of effective self-assurance as an integral part of a provider's routine operations. The wider discussion, of course, takes place on pages 25 through 28, mostly. However, it is proposed that this is a first priority. Also referring to the fact that the National Code 2018 and the ASQA Standards 2018 will necessarily involve a wider stakeholder group. So they're not just looking at revising the standards for RTOs 2015, they're also looking at revising the National Code 2018 and ASQA Standards 2018, which only came into effect really last year. And so I've sort of scratched my head and said, is this really what the sector called for? Because don't forget, this rapid review was supposed to be in response to what the sector was calling for. And I don't think this is what we asked for.
And I think a lot of RTOs just want the changes to stop unless they are fundamentally different and fundamental improvements. Because one of the things that drives RTOs mad, and always has done, is this constant update and constant change in the training packages, in regulation, in standards and laws, because every little change isn't a little change, it's a huge amount of work and cost at the back end.
And that's actually what my next question was about. The costs involved in this are significant, not just the standards for RTOs, but also the National Code and the ASQA standards. They are significant costs, and should someone be accountable for the significant costs that have already been incurred as a result of recent reviews to the standards, VET, National Code and ASQA, that are therefore allegedly so wrong?
And then you get full cost recovery on top of all that next year.
I have a question here. Are they looking at an ISO type setup where you, the RTO, do internal first party audits for a couple of years and then have an external third party review every 3rd or 5th or 7th year? I don't believe that there was any discussion about what they were considering in terms of changing the standards, only that they are. And in the executive summary, it was so small that you would have blinked and missed it, quite literally. But it's only pages 25 through 28 that we really start to see this being explored a bit further, to realise that it actually goes much further than the standards for RTOs, but is including two relatively new legislative instruments for which a significant amount of Commonwealth money was invested in the development and implementation, and so many providers are still struggling with. It's just astounding that this is even up for consideration. And so I wanted to have a discussion with everybody online to see whether or not they had understood that that is what's actually not just being discussed, but it's one of their first priorities. For me, that's a massive issue. And then going back to this concept of genuine providers, reference is made in the executive summary, as we saw earlier, in relation to proportionate responses to compliance action. Now, it was picked up again in relation to reconsiderations and decreasing the number of matters presenting before the AAT. The wording is subtle, but it is important given the word selected for use by MP Consulting and the obvious input from ASQA. Now, don't forget that the people behind MP Consulting, many of the people involved in that consulting group have a legal background. They are legally trained. And so the use of wording is quite important in terms of what they've documented and how they've documented it. But the way it's been reported also reflects for me that they've really taken a lot of this information directly from ASQA. The reason why I say this is because when referring to the providing realistic periods for genuine providers, what they refer to is it's not necessarily an indication that ASQA got it wrong. Now, that's something that we commonly hear from ASQA. We used to hear it a lot from the education videos. We hear it in the professional development workshops that they give, the webinars that they give. We hear it at the conferences that they attend, that all of these numbers and resolutions are not necessarily an indication that ASQA got it wrong. And it is exactly that wording. So to find it brought up again exactly in that format in this rapid review of ASQA finding suggests to me that they haven't actually got that information from anywhere but ASQA, which is a little bit concerning.
Yeah, especially when he who pays the piper calls the tune. And I mean, I know it doesn't necessarily come out of the, I don't know if the rapid review funding for it came directly from ASQA's account or it came from the department more broadly, but you know, this is a problem. Maybe it's, you know, entirely objective and legitimate. Maybe, you know, we've seen this so many times before, you know, firms will cooperate better depending on who's paying the money. You know, I mean, it's just a question. I'm not saying it's happened at all.
And I guess for me, one of the concerns is that genuine providers is such a subjective term, and it's open to abuse, and it's certainly open to abuse now, and it has been for many years. ASQA would appear to have a list of providers that it perceives to be non-genuine providers, and it chases after them no matter what the cost. If the culture problem isn't dealt with at ASQA, as we've been discussing throughout this video so far, then I don't think this is going to change. I think it is actually going to be the same. But why this is important as well is because what it talks about is giving providers the opportunity to enter into an undertaking or remedy before going to the AAT. Mm-hmm. Now, for me, this is problematic because there are so many times that ASQA does actually have it wrong. And if the issues we spoke about earlier are not addressed, this will continue to be used as a first port of call, and providers who don't question the validity and reliability of the findings are likely to accept undertakings or remedies that they wouldn't normally be required to or shouldn't actually be accepting. and it doesn't actually address the issue of underpinning quality and enhancing excellence in training outcomes. I've also got questions here. What do others see as being the right approach here? The review findings also bring up this concept of compliance teams and monitoring teams. And I was sort of asking, is this a good concept? In many cases, I see this as happening now. We have compliance teams who come in and do audits, and then we have monitoring teams who will go and review the outcomes of that audit, and they'll review the response, for example. So I see this is already happening now. I don't think that this is something new. So just to really sum up, for me, the rapid review has been a real missed opportunity. I haven't really gone into everything that I could have discussed here, but there is a lot more, but I think that we've covered enough for now. But I really do think that this is a real missed opportunity. I think that nowhere, the two biggest concerns for me are that nowhere is it suggested that I can see that there is a review of the competency and currency and experience requirements for auditors. And worse, it actually refers to the fact that auditors don't necessarily need to come from the vet sector.
Yeah.
For me, that is a massive, massive concern and a real missed opportunity, because I think that the whole basis of the decisions that are being made is premised upon the decisions being right to begin with. And a second big concern for me is that there's been a consideration of reviewing the standards for RTOs 2015. There's been a consideration of reviewing the National Code 2018 and ASQA Standards 2018, but nowhere did it say that there will be a review of the standards for vet regulators or the NVR Act in relation to the performance of ASQA, its staff, wrongful decisions, and where that leads us from here. I think what we're going to see is more of the same, and I don't think that we're really going to see any significant change other than the potential for people to get themselves into potentially more trouble than what they're already in. They're my final thoughts on the rapid review. I was hoping, like most people, to find a bit more positivity in it. At the moment, I'm feeling a little bit concerned, and I'm happy to hear what anyone else has got to say. Brett, what do you think?
Yeah, look, I do concur, and for me, the warning was in just the amount of stuff which is about, you know, making things better, not addressing the problems that have been uncovered, you know, and specifying exactly what they are. There's a lot of motherhood statements in there for me for a serious report, and I concur with all the points you've made. I see a lot of traps being laid in there, and I don't see this proper push, this anything with cut through that's actually going to improve anything. And there's nothing in there that's just going to change the culture of ASQA, and I do believe that is a serious issue. So no, I concur with everything you said.
I've got a message here from you too, Brett, to everyone, and I'll just read it out. With the NVR Act 2011 and the introduction of ASQA, Queensland negotiated a 12-month transition period for Queensland RTOs. Will we get a 12-month transition period with these new standards and other changes, such as the new focus on results? Interesting question, and I think we just need to look at how the National Code 2018 and ASQA Standards 2018 were rolled out. I think that will give us a very good indication as to what transition arrangements will be put in place. They say that history is very telling in terms of situations like these, and I think that in terms of the vet sector and international education in particular, I think what we've seen through the ASQA Rapid Review is absolutely that history tells the story of where we're going next. I think we've been here before. This is just another trip around the merry-go-round, unfortunately, and it's a really big missed opportunity for the vet sector and international education. They're my thoughts. Thank you everyone for joining. If you've got any comments, please feel free to continue the discussion after the video on LinkedIn, YouTube, via email, RTO Doctor Facebook page, and I look forward to engaging with you further. Thanks very much.
Thank you, Raylene, too, for going to the effort and putting songs. I know there's a fair bit of work behind it.
Thanks very much, Brett. Bye for now.
Bye.